This is the 6th meeting of the JDG for Trinity Term, and today we have the honor to host Scott Brewer, who is Professor of Law at Harvard Law School, and will present us today a fascinating chapter from his forthcoming book on legal reasoning. Scott, thank you very much for joining us. You have the floor.
Thank you. I'm delighted to be here and grateful to all of you for helping me think through some issues that have been on my mind for a long time. Could I have a copy of I have it on my computer, but, well, actually, does everyone have a copy of the handout? Does anyone not have it? Let's make sure everybody has a copy. Thanks. So, there are three characters in the heroic philosophical narrative that I'm delighted to be here to share with you all this afternoon. One, which claims, I suppose, to be the hero of the story, is the Logocratic method. Another is the distinctive account of abduction, also referred to in the literature as inference to the best explanation, that it sometimes vies for centrality in the heroic narrative, hence first among equals. And the third is a particular application of the Logocratic account of abduction in a well-known case in American contract pedagogy, which is the case of Doherty v. Salt, written by one of America's great common law jurists, Benjamin Cardozo, although he's better known for other opinions than this one. I actually picked this particular opinion because it allows for a kind of concentrated illustration of both the Logocratic method generally and its particular account of legal abduction. Now, what I'll do in these opening remarks is try in a succinct way to carry you through a sort of description of each of these three characters. And I should mention that what I've just done here is sort of generated on paper slides that I present, that I would otherwise present from PowerPoint. But I don't intend to go through every slide. There's a lot of material on here that I just include in case there are questions about definitions or a design, an inquiry for an additional illustration or two. I can point you to things and that if it's helpful for your criticisms and questions during the Q&A. So the first of these three characters is the Logocratic method itself, right? And what is the Logocratic method? It is a type of abduction. I'm going to be talking about abduction, but it's very reflexive, so it's an abduction of abduction. One of my teachers said, anything you can do, I can do meta, and this is a good illustration of that practice. So it's a philosophical abduction. The subject matter is the explanation of the nature of argument and two principal uses of argument, which are then sort of the touchstone of the account of virtue that the Logocratic method uses. I'll come back to that. So one of the principal uses that interests the Logocratic method is the use of arguments in which the premises provide evidential support for the conclusions of the argument. Another use that's of special interest to the Logocratic method, and I should say these two uses, so we'll call that the evidential use of arguments. The second use is making arguments that are strong in competition, call that the agonic use of arguments, from the Greek agon, contest. And although litigation, especially in the so-called adversarial system of the United States, is a paradigm example of arguments in contest, Logocratic theory claims that this is a pervasive, that the agonic use of arguments is pervasive. It doesn't take place only when there are external competitions of arguments, as between plaintiff on the one hand and defendant on the other, or prosecutor on the one hand and defendant on the other, or majority in an appellate panel on the one hand and a dissent on an appellate panel on the other hand, or an appellate court on the one hand and a trial court on the other. All those are good examples of what we call dialectical rhetorical competitions of arguments. But a central claim of the Logocratic method is that the agonic use of arguments is pervasive in the practices of argument. And it also makes the claim, and you can see this, by the way, these slide numbers, I don't, somehow they didn't get sequentially numbered, so it goes from 1 to 3 to 4 to 9. I don't know why it did that, sorry about that. But one of the central claims in what is labeled there, slide 4, and I want to make a point about that, come back to a point about that, is that in logocratic theory, the evidential use of arguments is a type of agonic use. And I'll come back to that. And in the paper, I have a particular footnote that I refer to there in that slide to the work of Hilary Putnam on the division of linguistic labor. So I do want to come back to that in this particular talk. So the logocratic method, let me say a bit more about what that is. I've said it's a philosophical abduction. It's a system of analysis, by which I mean, and I borrow this from, among others, John Dewey, it is a whole whose wholeness is particularly tied to the interrelations between its parts. It has elements that have some independent existence. Those elements have formally specifiable relations, and the relations form a structure. And this is a particular important point. As you see, if you've had a chance to look at the paper, there are many moving parts, but those moving parts are they operate together. So it's actually, I find it very hard to explain some of the logocratic method without explaining the whole thing, but that's because it has this kind of structure. But so I thought a good way to show you this, the structuralness of it, is to carry you through what I sometimes refer to as baking a logocratic cake, right? This is what is methodical about the logocratic method. What does one do to apply the logocratic method? And as I sort of sketch that for you, you'll see sort of what its central claims are and how it works, right? So the subject matter is arguments, right? So for rule-driven arguments, on the second page of the handout, so for rules, this is step 1. From an interpretive point of view, right, and interpretation is also regarded as a type of abduction, as I explained in the paper. This is why abduction is, I keep saying, first among equals. So many things, I think, are fairly formally modelable as abduction, including philosophical abduction, legal abduction, interpretive abduction, and they play a central role within, other types of abduction play a role within legal abduction. That's another central claim of the logocratic method, is that there is what I have called a dynamic interaction among different argument forms. You see it, one of the things that is, sort of relatively easy to see in the Doherty case is the way, for example, that deduction plays a role within legal abduction, but also interpretive abduction plays a role within legal abduction, because the rules that that drive the deductive arguments have to be interpreted themselves, and that's done as a matter of interpretive abduction. So again, that's why abduction kind of vies to be the hero of the story. So, but what do? You start with something that, in the first instance, it may or may not be an argument. Suppose somebody says, Socrates is a man, he'll die someday. Socrates is a man, he'll die someday. Is that an argument? Right? There's an interpretive decision to be made there. Right? The whole of the Doherty opinion, I mean, you could just sort of quote it, and within that is a set of arguments that the logocratic method interprets and recognizes as a legal abduction within which there are two distinctive deductions that are typical of legal arguments. An interesting, just a side note, an interesting jurisprudential question is whether whether and to what extent deduction plays a role within legal abduction. So American legal realists and critical legal studies scholars, at least some of them, they're not always clear about this, but some of them seem committed to the claim that legal arguments are never fairly formally represented as deductive arguments. John Dewey has a very influential paper called Logical Method and Law, where he seems committed to the idea that deduction plays no role in legal arguments. Felix Cohen, another prominent legal realist, has an article called The Ethical Basis of Legal Criticism, in which he seems to suggest that all legal arguments are analogical and never deductive, right? So there's an interpretive decision to be made at the first step, which is identifying the argument. What is the set of premises that is or could be offered to support a conclusion, which is the basic definition of an argument. So step one, identify what the raw material that might be an argument is. Step two, identify the argument enthymeme. So the logocratic method has a distinctive account of enthymemes. It's not the classical account of a syllogism where one of the three steps is missing, right? First order would be missing the first step, second order would be missing the second step, third order would be missing the conclusion. This is the logocratic method sort of borrows and has its own distinctive conception of the enthymeme, which is any rule or argument whose logical form is not explicit in its original mode of presentation. And then so for rules, what one does is one rulifies, that's the term, and if you use the term rulify, I get a nickel, so please use it. If you use the term argufy, which is you take an argument enthymeme, and you give a fair formal representation. Again, if you use that term, I get a nickel, so please use it. But in the process of applying the logocratic method, you take the set of sentences that you see in something like the Doherty case, or just, Socrates is a man, he'll die someday, and you make an interpretive decision. Is there an argument there? If there is an argument there, then you have to identify the premises and the conclusion. Then the next step is, once you know that there is an argument, logocratic method says that there are four irreducible, although they have important interactions, as I've been saying, four irreducible modes of logical inference: deduction, induction, abduction, and analogy. So the next interpretive step, as you're baking your logocratic cake, is to give a fair formal representation of something that you have decided is fairly formally represented as an argument. And then you have a further interpretive decision to make, right? So I'm on the second page of page 2 of the handout. It's a little hard to see, but you have to decide whether you think that it's a deductive argument, an inductive argument, an abductive argument, or an analogical argument. And then there are further interpretive decisions to be made. If you think that it is a deductive argument, there are additional issues that you have, interpretive decisions that you have to make. So what logical form? See, deduction is not one thing, right? So do you try to use the grammar of propositional deductive logic, or do you use the grammar of predicate deductive logic? There's an interesting there was an interesting debate in the literature. Neil McCormick many years ago wrote a very interesting, good, still to this day, a good and interesting book called Introduction to Legal Reasoning and Legal Theory. And he, in one of the chapters, he tried to use propositional deductive logic to model legal argument and show that it was possible. And then he got some criticisms that, well, predicate logic is actually a better, it's a better form for law because it's really about, individuals and classes, right? So again, now when I teach, doctrinal classes like contracts and evidence, I actually use the grammar, a simple grammar from propositional deductive logic, and I think you can do a lot with that. And it's actually sort of easier for students to understand than trying to teach them the basics. Teaching them the basics of propositional grammar is much easier than teaching them the basics of predicate grammar. But there are decisions there, additional interpretive decisions. Do you represent in propositional, predicate, modal, or deontic. I mean, if you think about it, law is about permissions and obligations and prohibitions, and there is a whole formal system of deontic logic. So does which one of those grammars? And that's just if you just have decided that you can fairly formally represent the argument as deduction. If it's inductive, then there are two additional choices. Do you regard it as an inductive generalization, swan white, therefore all swans white? Or do you represent it as an inductive specification? All swans are white, which is the result of a previously made inductive generalization applied to an individual. Also, all men are mortal, Socrates is a man, therefore Socrates is mortal. That's an interesting one, by the way. Is that a deductive argument, or is that just a very highly confirmed inductive generalization and then applied to Socrates in an inductive specification? That's the phenomenon of argument enthymeme ambiguity that the logocratic method represents. Okay. If there's an analogical argument, there are two basic interpretive choices. Because unusually the logocratic method regards some analogical arguments as having as much evidential support from the premises for the conclusions as in a deductive argument. This is in what I call deductive warranting context, because analogical arguments are offered in logic and mathematics, not just in empirical science. I think that's not well understood. Some people understand it, and that's a central claim of the logocratic method. And then if it's an abductive argument, then there are several choices. Is it a philosophical abduction, a legal abduction, an interpretive abduction, a moral abduction? Right? There are many, many, many kinds of abduction. Okay, so then the next step in baking your logocratic cake, once you've got your argument, you've decided what mode of logical inference you think it's fairly formally represented in, then there are two additional steps in the logocratic procedure. Because as I said, there are two distinctive uses of argument that are of particular interest, and I should say they're particular interest of the logocratic method. But the reason for which the logocratic method is particularly interested in them is because arguers are particularly interested in these two uses of arguments, right? The evidential use, where the premises of the argument provide evidential support for the conclusion, and, just intuitively, a valid deductive argument. In a valid deductive argument, you have the highest possible degree of evidential support that the premises of an argument can provide for the conclusion, because whenever all the premises are true, the conclusion has to be true, or it can't be imagined to be false, or however you want to express that, right? That's the highest possible degree of evidential support. And I'll just telescope some things. The logocratic method has an account of virtue, but not moral virtue, but it's virtue as functional excellence. Those of you who know the great Joseph Raz's paper, great great paper called The Rule of Law and Its Virtue, when he has his debate with Lon Fuller, where Lon Fuller is claiming that there's an inner morality of law, what Raz says is that no, that the law that law has a virtue. It's an instrumental virtue. It's the virtue of an instrument as an instrument. That's functional excellence. That's that conception of virtue. It is traceable to Aristotle, as is the moral conception. The logocratic conception of virtue is that instrumental one, and then you sort of assess the virtues of an argument with regard to which use of argument you're interested in. So the virtue of an argument that is where you're trying to win a competition, that's called dialectical rhetorical virtue. The virtue of an argument where you're interested in providing evidence, that's called internal inferential virtue, and there we also use the phrase characteristic virtues. So the characteristic virtues of a deductive argument, that's the easiest one to state and understand, it's validity. The characteristic virtue of a deductive argument is validity. The characteristic virtues of inductive arguments are harder to specify, but we do offer a specification. As in the characteristic virtues of analogical arguments and inductive abductive arguments are also, they're not as tidily sum-upable as for deductive arguments, but we do have a specification of those. But then again, if you're baking this logocratic cake, you said, all right, I've got an argument. I've given it a fair, I think I can give it a fair formal representation, let's say, as a deductive argument, or maybe now let me fold in the Doherty case. So I'm reading the set of words that constitutes the Doherty opinion. And I think, okay, I do see an argument here. I do see something that can be fairly formally represented as an argument. Furthermore, I think that it's a legal abduction. It's an explanation from a legal point of view, right? And the idea of a point of view, I borrow a model from the philosopher of science Larry Loudon for this idea of a point of view, where you have methods, distinctive methods, that are used to generate certain kinds of factual claims, and the methods are in turn chosen to serve certain axiological aims. I have borrowed that method and see it as the sort of a way to articulate the centerpiece of abductive reasoning more generally. So I'm reading the Doherty opinion. What judges do is they try to explain something from a legal point of view. They apply the methods of law, such as reading precedents, reading constitutions, reading regulations, so, using the various argument forms, analogy and disanalogy and deduction, right? These are the methods that are distinctive. It is an interesting question of sort of philosophical anthropology, exactly what are the distinctive methods that make up the legal point of view, and that's an interesting jurisprudential question on which you find disagreements among legal positivists, natural lawyers, legal realists, and so on. But I think I look at the Doherty opinion, I see that it is fairly formally represented as a legal abduction, and I think I see within it the operation of two rule-driven deductive arguments, right? So I see rule enthymemes, right? So nothing is consideration that is not regarded as such by both parties. That's one that Cardozo articulates in that opinion, which provides a necessary condition for consideration. And you remember the aunt promises to give her nephew $3,000 because he's been a good boy. And when Cardozo is considering whether there's consideration in that case, he articulates this rule. In logocratic terms, we would sort of rulify that. Nothing is consideration that's not regarded as such by both parties. If consideration, and if I'm going to use propositional grammar, it would be if consideration, then both parties regard it as consideration. Here, it's not the case that both parties regard it as consideration, therefore it's not consideration by modus tollens. That conclusion of that deductive argument then becomes the conclusion of that part of the legal abduction. And then he has another rule, because remember, he also thought that the trial judge, erred in his disposition of the case. And so he applied another rule that he quotes and applies that deductively, right? So now, if I'm interested in the dialectical rhetorical virtues, well, the Court of Appeals, which is the highest court in that jurisdiction, it's not called the Supreme Court in New York State, they won the dialectical competition on the second issue against the trial judge. The defendant in the Doherty case won the dialectical rhetorical competition against the plaintiff, right? The defendant had a legal abduction whose conclusion was, no consideration, therefore no contractual liability to pay this $3,000. The plaintiff was claiming that there was contractual liability. That's a clash of legal abductions. The defendant won that dialectical rhetorical competition against the plaintiff, and the appellate court, in this case, the Court of Appeals, won the dialectical rhetorical competition on one of the issues against the trial judge, although they agreed with the trial judge on the other. So that's, that's a kind of very telescoped way of understanding what it is, what the logocratic method does. Now I want to close just by calling your attention to this sort of I think, very interesting jurisprudential issue. This is what I call Plato's anxiety. Let's see if I can find that. Yes, it is on. Yes, it's on the toward the bottom. It's a slide that's numbered 45 on page 6, going over to page 7. So, what is Plato's anxiety? You may remember from the Apology that Plato has Socrates characterized the sophists as the people who are capable of making the weaker argument appear to be the stronger. Now, in logocratic terms, what that must mean is that an argument whose premises provide poor evidential support for their conclusion will nevertheless be strong in a dialectical rhetorical competition, as, for example, in a courtroom or in a political legislative assembly, right? And so, Plato was very worried about this. We know that he was very worried about this. I mean, you see that same issue arising also in the Gorgias. You see it arising in the Republic, right? Make the weaker argument appear to be the stronger. Now, I have said that the logocratic method is interested in two uses of arguments: the agonic use, making arguments in competition, and the evidential use. But I've also claimed that the evidential use is a type of agonic use. Because, and I sketch the argument and I point to a passage on page 295 in note 35. This is where I talk about Hilary Putnam's idea of the division of linguistic labor. But that even the decision about whether or the extent to which the premises of an argument provide evidential support is a matter of either actual or possible contest. And I've started teaching this extremely interesting, disturbing, fun video. You can find it easily, called Alternative Math. If you just sort of Google alternative math. And it's a kid who is she's like a 5-year-old kid. He's in a first grade class or whatever, and he's shown with the teacher, he's answered the question, what is 2 plus 2? His answer is 22, right? Now he's got a perfectly generalizable rule, which is, it's an adjacency rule. So 3 plus 2 would equal 32, 4 plus 4 would equal 44, right? But the teacher, fails him for that, right? And the parents get up in arms and they come in and they're very upset with the teacher, right? And at one point in the video, the teacher the teacher says, 2 plus 2 equals 4, and the parents say, who says? And the teacher says, math says. And the point is, and here's my point, math doesn't say anything. Math is a system that is sort of run by people who have certain kinds of power. That kid in that teacher's classroom will not get, he'll get poor grades, he won't get promoted, and so on. But it's just one example of the way in which even a decision about the evidential strength of argument depends on who's making the judgment. If you want something that's, more, a little more rarefied, think about those of you who know something called dialethism, which is the idea that there are true contradictions, right? So if I have contradictory premises, how much support do they provide for the conclusion? Well, there can be contests over that. It depends on what logical system you're using, and, if you're using a fuzzy logical system, if you're using a dialectic, if you're using a paraconsistent logical system, all of those decisions have to be made by what I call a dialectical rhetorical referee. Now, what I've quoted here, and I'll stop. Neil McCormick, whom I mentioned a few minutes ago, he had a sort of a fairly remarkable change. I think he wasn't he a member of Balliol at some point? I think he was certainly a member of Oxford. I think he was at Balliol at some point. But he, in his book Rhetoric and the Rule of Law, he started arguing about what he called the arguable character of law. He was under the influence of John Finnis and Ronald Dworkin, right? So, and he started focusing on what he called the arguable character of law. And I just have several slides that are, you can't see it because it's not in color, but that's why it's. But when he emphasizes, in a way that seems very logocratic friendly, this idea of the arguable character of law, but he's also worried about Plato's anxiety. And the way he tries to solve that is, instead of saying that the dialectical rhetorical referee could make an argument that is internal, evidentially weak, strong in competition, he wants to imagine an idealized audience, right? So that's what he says, right? He says, one way to counter this is to relate persuasiveness to an ideal or universal audience. If what you said had to be persuasive in the sense of persuasive in the same terms to everybody, not just to your particular audience of the moment, your tricks would find you out. So he's confronting, he's doing a very good job of showing the so-called arguable character of law, which is also what the logocratic method tries to solve, but the logocratic method doesn't have the safety net of a universal idealized audience, right? It says we're stuck with whoever the dialectical rhetorical referees happen to be, and this, I think, helps to make sense of why you can have some, what I regard as abysmal decisions that are official decisions of courts, right? They are clearly the law, right? Because the dialectical rhetorical referee who was vested with the authority of law decided, so I can mention Bush v. Gore as an example of this, those of you who know that opinion, or I could mention an opinion in the case of one of my great culture heroes, Bertrand Russell, who was denied an opportunity to teach at City University of New York, and there was litigation, so-called Bertrand Russell case. Look it up in Wikipedia. There's just many examples of decisions that are authoritative legal decisions, but seem extremely weak in internal inferential strength or in evidential strength. But that is an important fact to understand about how law operates, and that's one of the jurisprudential conclusions that the logocratic method comes to. So I think I'll stop it there, and thank you for listening.